Hello, everybody. Bear with me while I finish getting things set up. This is my first video that I'm doing on these different platforms, and um, I'm not the most technical savvy person, or I don't even know if that's the correct terminology, but computers and stuff like that's all new to me. Um, but I do realize that this is the means for us to get information out to the masses. So I am forcing myself to learn the game, the social media game, the internet game and hustle. I gotta learn it, and so I can stay in the loop. And so that I can also get information out that I consider to be valuable to people so that they can also stay in the loop. Um, if you all have been following me or, associated with me on any of my personal social media platforms, you will know that I am currently working on the grand opening or, ribbon cutting ceremony for my nonprofit organization, Community Bridges Incorporated. We will be having the event this Friday, February the 19th. And due to the weather and all the other um, health restrictions, I realized that social media is going to be probably the best way for me to go about getting the information out to the most amount of people. Because the one thing I like about social media is that it allows you to reach a unlimited amount of people, and then you don't have to worry about all of the social distancing and the space for parking. You don't have to do all that. So in a sense, it's pretty cool, and I'm not discouraged by the fact that even though I've already reserved the space at a facility, um, I don't look at it as a loss, and I may still even go and do the event from the facility. It's just that it won't be. I won't be expecting anybody to be there because of the ice and everything that's going on. But I think I may do it there just so that I can have the ambiance of the environment that the dance studio, the dance complex has. Um, that was one of the things that really attracted me to that location was the decor, like the unity and diversity. Um, for my organization, Community Bridges Incorporated, unity and diversity is a major part of what we stand for and what our mission and goal is. Um, I even think I had my mission statement written down somewhere. I'm gonna share it with y'all because what I've been doing is like finding a lot of information as I am getting ready for this event. Like I've been preparing for this moment for a few years now, and so the fact that um, so many other things are happening in the world, on top of me dealing with my battles with housing discrimination and disability discrimination, um, it makes it complicated and difficult to keep up with a lot of paperwork and documents and to keep things organized when you don't have stable housing. And so that part by itself has been a major struggle. However, I have been um, fortunate enough to kind of keep a lot of my things somewhat together so that I know that I have access to it, if nothing else. Um, so the reason why I wanted to come on and do this video today as a surprise It's because I received a surprise last night. And, I like to share. I'm not stingy with my surprises. So the surprise is like, okay, so the main focus areas for the event will be talking about um, affordable housing, disability discrimination, and judicial corruption. And I know that last one is something that a lot of people are kind of hands offish about because of their own experience with the judicial system. Um, but sometimes you are put in situations to where you, regardless of if you're afraid or fearful, you're put in a position to where you have no choice but to fight back. So in the process of fighting back, you start realizing how involved more people than who you thought you were fighting. You'll be thinking you're fighting one person, but really you're fighting a whole system. And it takes a long time before you can actually piece everything together to see why everything's been so difficult. And after you get so many doors slammed in your face, you'll start personalizing, why is this not working for me? And then Lord forbid you have some people in your surrounding, your immediate community or family that tend to want to try to place the blame on you instead of looking at the bigger picture. It's real easy for them to say things like, well, you shouldn't have done this or you should have done that, all the while ignoring the whole issue of the institutional corruption. Like they have made an institution out of the corruption, and it leads to our systemic oppression. That's what we're going to talk about. And the issues that I'm not going to bring issues. I'm going to bring facts to you today because I received these facts last night by accident. And when I say by accident, I was actually gathering information to be able to, when I'm speaking on Friday, I like to have case law ready to support whatever it is that I'm proposing to people or trying to make them aware of. I like to be able to show a legal case and how this played out in other people's lives and in other courts and stuff. And as I was searching, I ran across an update on my federal case that I had no idea had even been addressed, because the last time I heard from the court here in Middle Tennessee, the federal court, they had dismissed my case on, what was that, May the 4th. And so because they dismissed it, I had filed judicial misconduct complaints against the federal judges that dismissed my case without ever even, I never ever received a hearing, a case management, or like anything, none of the procedural things that come along with due process. I was denied all of that. And in the process of that, I was evicted wrongfully. And, it's almost as though when you are brave enough to speak up, the people that are doing things to hurt you are offended by it. And so they will, attack your whole character, make you have to be something that you're not, just to protect and to keep cover over what they're doing. So with all that said, after they dismissed my complaint on May the 4th of 2020, I filed my judicial misconduct complaints. The judicial misconduct complaint, it sat for almost a year in the federal court in the Sixth Circuit Court in Ohio. They just let it sit there for over a year, and then they turned around and dismissed it without my knowledge. They didn't ask me any questions. I mean, so these people have totally just denied my right to due process. I can't be heard. I can't get any type of reasonable accommodations, because with me being a person with a disability, reasonable accommodations would allow me to have an equal opportunity or equal chance at actually being heard fairly, because I'm not an attorney. I study the law. I study it because I have to in order to defend myself, because I can't afford an attorney. But when there are federal programs in place that say a person such as myself should be entitled to a court-appointed attorney when we need it, we should not be denied that right without even giving a reason or justification. And then to turn around and deny us housing because of, us not being able to effectively represent ourselves as attorneys. And when we start looking at the fact that it's not so much that we're not able to effectively represent ourselves, it's just that the courts that are hearing our arguments refuse to hear what we're saying because they are part of the problem. They don't want us to be right. They don't want to give us justice. And so how do I know this? Here's where we at. After they dismissed my complaint, and once I get, now that I got my YouTube thing going, which I'm streaming over there too, so that's why I'm not really looking at y'all. I'm looking like, I got like 3 screens up right now. I'm going to figure out how to upload these documents so that y'all can review them. I might have to reach out to my homie Talk Black to Me. I guess, what is his name? Talk Black to Me TV. Y'all know who I'm talking about over there. So he can show me how he put his documents up so I can show y'all and just let you see. Because how do we go from you telling me you just dismissing it and you ain't trying to hear nothing that I'm saying, but then after I file my judicial misconduct complaint that sat for over a year and they dismissed that, I filed a complaint against those judges on October the 6th of 2020. 20 days later, on October the 26th, the federal court enters a whole new order on my case that I wasn't aware of. But when you read this order, you would think like there was never a gap in between, like I should have known to be waiting on this response. But it's not the truth. The truth of the matter is these people never gave me the opportunity to step foot in the courtroom. They never even filed my amended complaint yet. That's what they used to determine the whole case off of. They never even served the amended complaint on anybody, but yet dismissed the whole case. It's just a lot. It's a lot. But where we are today, the paperwork that after I filed my my request for review with the when they had dismissed my complaint with the Judicial Misconduct Board. Let me get the document from what the court said. And this is some good shit. Like, even though it's delayed, very, 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 very delayed, and there's a whole bunch of lies even within this order that I am going to go address, because I've addressed it in my judicial and the response that I sent to the judicial misconduct people. But see, they didn't expect me to get this, I don't believe, because all of the lies and the misrepresentations that are in here to help protect other people, other entities that were included in the complaint. It's like the judges are being the attorneys for these people, because the attorneys are not even having to file this stuff. These are the courts doing this. See what I'm saying here? So they're overstepping their boundaries, like totally. But the good part, and I could tell it killed them to do this, but the only reason why they did it is because they got word from in Ohio. Let me get down to the good part. The whole issue, it says right here. Okay, I'm gonna give you the analysis. Okay. With the dismissal of Murfreesboro Lease Housing Associates and Chariot Point, there are 6 remaining defendants: Dominion Management Services, Murfreesboro Housing Authority, Mental Health Cooperative, Volunteer Behavioral Health System, the City of Murfreesboro, and Rutherford County Sheriff's Department. Before addressing plaintiff's specific claims against these defendants, the court reiterates that a parent can only bring suit on behalf of a minor through an attorney. That's a whole argument that I'm not even going to have right now, because once again, these people make these laws up to suit them. They know we can't afford an attorney. That's why we're asking for right to counsel. So they're saying a whole bunch of stuff about res judicata for dominium. But then we get down here to Murfreesboro Housing Authority. Here's where it gets good. I want to point out here too, it says plaintiff also brings this action against Murfreesboro Housing Authority, the entity responsible for monitoring compliance with the Shelter Plus Care program. Now, hear me out. This is the federal court stating this as their analysis. This is not my opinion. I'm reading off of the case law, but I'm gonna upload this stuff. So they're saying that Murfreesboro Housing Authority is the entity responsible for monitoring compliance with the Shelter Plus Care program. And it says Murfreesboro Housing Authority provided plaintiff housing assistance payments through the program. It says the precise nature of plaintiff's asserted claims against Murfreesboro Housing Authority is not entirely clear. Well, it's not entirely clear because you never gave me the opportunity to come in before the court to even be heard. Only thing they're going off of is what I wrote to them. And everybody knows anybody can misinterpret or misconstrue and omit on purpose things that they're reading in a legal document, pretend to be stupid when they know very well what's been said. They know it enough to be able to twist it around to benefit the other party. So it says, liberally construing the amended complaint, however, the court understands plaintiff to be asserting that Murfreesboro Housing Authority violated her rights under the Shelter Plus Care program, Section 8 of the Housing Act of 1937, Section 504 of the Rehabilitation Act, the Fair Housing Act, the Tennessee Consumer Protection Act, the Americans with Disability Act, the anti-retaliation provision of the Rehabilitation Act and the American with Disabilities Act, and the Due Process Clause of the 14th Amendment. The court will address these claims in turn. Now, let me go back just to say, the court did not address any of this stuff when my case was open, when I was asking them to. It took me having to file judicial misconduct complaints against them and the Federal Court of Appeals judges to get them to come and address these issues. This is not right. This shouldn't be required. I mean, you are creating barriers to prevent me from being heard. And so you're interfering with my rights to due process. And okay, so it was a document that, because this document is long, I think they made this like a 30-page document. 24. And the document that I read last night, it kind of gave a summary of what their conclusion was. And that was where I'm really trying to get to now, just to show y'all where we are with this. But in the process of them getting to that, they do go over a lot of case law for the supportive housing program, the Shelter Plus Care, that I am so glad I put that stuff in there, because now this is something on record that other people can use and have access to when they need a reference or case law or something to cite. You see what I'm saying here? Once you file it, especially federal court, it's part of the record, regardless of whether they want it to be or not. That's why I be telling y'all, file those complaints. One thing I do notice right here before I get skimmed through to where I'm trying to go, it says the court is unaware of any prior case considering whether these particular statutes contain the type of rights creating language that establishes an enforceable right of action under Section 1983. But the Sixth Circuit has held that similar language in another federal housing law does not create such a right. In Johnson versus City of Detroit, the plaintiff alleged that defendants violated Section 8's requirement by failing to provide decent, safe, and sanitary housing. The Sixth Circuit found that the relevant statutes either presented broad policy statements regarding the federal government's goals, or they had aggregated focus on the entity being regulated rather than individual tenants. Although residents of public housing undoubtedly benefited from the sanitary provisions at issue, the court explained statutory text that merely benefits punitive plaintiffs is insufficient to confer a new federal right under 1983. Okay, so they say here, as in Johnson, the statutes authorizing the Shelter Plus Care program focused on the government's goal or the entities regulated rather than individual beneficiaries. It says, in particular, the program supportive service requirements were directed at the HUD secretary and recipients, meaning states, units of general local government, or public housing agencies. Statutes that focus on the person regulated rather than individuals protected create no implication of intent to confer rights on a particular class of persons. The court therefore concludes that the plaintiff does not have private right of action to enforce the supportive service requirement of the Shelter Plus Care program. Accordingly, plaintiff fails to state a claim against MHA on this basis. I totally disagree, because he even said there himself that the court is unaware of any prior case considering whether these particular statutes contain this type of right. So you're going to go now. For one, we know that Section 8 and Shelter Plus Care are two different programs, and you're reciting case law based off of a Section 8 program. Section 8 is not entitled to supportive services. Duh. That's the whole difference between the Shelter Plus Care, shelter, housing, care services. But I'm the one with the mental health disability, Anyway, okay, I'm gonna try to keep this professional. Let's see. So then they go on down to the Rehabilitation Act. They did say that it was these are the ones where they said, I have 2 claims remaining. Okay, that's where we're going here. I didn't know it, but my federal lawsuit, the one that we're doing the petition to get some awareness on over here, and I'm trying to collect signatures on, and I barely got 30. I didn't even know it, but they already done reopened it and said that it says, nonetheless, after they said a whole bunch of crap trying to wish they didn't have to say what they're about to say, nonetheless, liberally construing plaintiff's allegations in her favor, the court cannot conclude that plaintiff fails to state a claim on the basis at this juncture. Accordingly, plaintiff's reasonable accommodation claim will be allowed to proceed for further development. Boom. Boom. Okay. Then, so that was the claim under the reasonable accommodations. Due process. So it says, I'm gonna read all of this to y'all because they tell on themselves without even realizing it. I don't guess they expect us to read. I don't know. It says, finally, plaintiff asserts that Murfreesboro Housing Authority terminated her from the Shelter Plus Care program without due process. Procedural due process imposes constraints on governmental decisions which deprive individuals of liberty or property interest. Property interest within the meaning of the due process clause of the Fifth or 14th Amendment. So they give Doe versus Miami University, they cite in some cases. A participant in the Shelter Plus Care program has a legitimate property interest in the continued receipt of benefits under the due process clause. Hello. So what was all that other stuff they were saying up on that other one where they were saying they wasn't sure? Well, you said right here, a participant in the Shelter Plus Care program, which that's the program that I'm a part of. So that's what you need to be using on that other one where you tried to say that didn't apply. You see? Okay, we're gonna correct all that though. Don't worry. It says a participant in the Shelter Plus Care program has a legitimate property interest in the continued receipt of benefits under the due process clause. Interest in the Shelter Plus Care rental subsidy plainly is a protectable property interest deserving of due process protection. Indeed, a statute governing the Shelter Plus Care program provided that when terminating an individual's benefit under the program, that individual shall be provided a formal process that recognizes the rights of program participants to due process of law. 42 U.S.C. section 11403 FB, and that was in 2010. Because the termination of Shelter Plus Care benefits implies a constitutionally protected interest, the question remains what processes do. To answer that question, the court considers three factors. Number one, the private interest that will be affected by the official action. Number two, the risk of an erroneous deprivation of such interest through the procedures used, and the probable value, if any, of any additional or substitute procedural safeguards. And number three, the government's interest, including the function involved and the fiscal and administrative burdens that the additional or substitute procedural requirements would entail. And they quote Matthews versus Eldridge, 1976. Additionally, a regulation implementing the Shelter Plus Care program provides that recipients, again meaning states, units of general local government, or public housing agencies, must exercise judgment and examine all extenuating circumstances in determining when violations are serious enough to warrant termination, so that participants' assistance is terminated only in the most severe cases. 24 CFR section 582.320A. In terminating assistance to a participant, a recipient must provide process that includes at a minimum, number one, a written notice to the participant containing a clear statement of the reasons for termination. Number two, a review of the decision in which the participant is given the opportunity to present written or oral objections before a person other than the person or a subordinate other person who made or approved the termination decision. And number three, prompt written notice of the final decision to the participant. Here, plaintiff alleges she was terminated from the Shelter Plus Care program, and the court is unable, now hear me now, they can determine everything else based off of wrong information, but this is what they said. And the court is unable to determine from the face of the pleading whether Murfreesboro Housing Authority provided plaintiff the minimum process due in these circumstances. Accordingly, plaintiff's due process claim against Murfreesboro Housing Authority will not be denied at this juncture. Now, if you read that and didn't really pay attention, you would think that he was saying that it was going to be denied, because they said accordingly, the court is unable to determine from the face of the pleading whether Murfreesboro Housing Authority provided plaintiff the minimum process in these circumstances. Accordingly, plaintiff's due process claim against Murfreesboro Housing Authority will not be denied at this juncture. Just say that it will be able to move forward, like you said on the other one. I mean, you're coming up with all of these other things that really don't make sense, because if you're supposed to interpret, if you're supposed to take what I'm telling you as the truth until somebody proves me wrong, what did you talking about? You can't tell by the face of it. All that was unnecessary. I mean, I said it. I don't have a reason to lie. They even came up with the case law to show that what was supposed to happen, obviously, it didn't happen. So they go on about, now they've tried to take all of my claims against everybody else, and y'all know I had all of those people on there. They've dismissed everybody else from it besides Murfreesboro Housing Authority. So in the conclusion, it says, for these reasons, the court concludes that the amended complaint states two colorable, check that word, colorable claims against the Murfreesboro Housing Authority: a reasonable accommodation claim under Title II of the Americans with Disabilities Act, and a due process claim regarding plaintiff's termination from the Shelter Plus Care program. Check this. Once again, their opinions being incorporated into these legal decisions. We're going to bring this out to the table. It says right here, it is unclear at this point whether plaintiff will ultimately prevail on these claims. Rather, at this stage, the court concludes that these two claims survive screening under the standard for cases filed in forma pauperis. The remaining claims and defendants are dismissed. The court's determination that the amended complaint states a colorable claim for purpose of initial screening does not preclude the court from dismissing any claim at any time for the reasons set forth in 28 U.S.C. 1915E2, nor does it preclude any defendant from filing a motion to dismiss any claim under the Federal Rules of Civil Procedure 12. This action is referred to the magistrate judge to oversee service of process on Murfreesboro Housing Authority, enter a scheduling order for the management of the case, dispose or recommend deposition of any pretrial motions under 28 U.S.C. 636B, 1A and B, and to conduct further proceedings if necessary under the Federal Rules of Civil Procedure and the local rules of the court. It is so ordered, Judge William Campbell, Jr. That was filed on October the 26th of 2020. The issue that I have is that my amended complaint was filed on August the 17th of 2018. And we just now getting to you deciding that you're going to serve Murfreesboro Housing Authority about my issues that y'all been done had knowledge of. And now that I'm thinking about it, I can remember, because I have a P.O. box that I've been using to get my mail from. I remember there was a piece of paper in there that was like, you need to sign for something, but I didn't know where it was from, and I just didn't sign for the shit. I thought it was from not Chariot Point, the people that Warren Properties, the one that I'm, most recently in court with. But now that I know what this is, I had to look at the dates. And so I immediately realized that these people didn't send this to me because they were following procedure. They sent it to me in response to me filing my response for, about the federal court not investigating my complaint correctly, my judicial misconduct complaint. The point being, these people do not do what they're supposed to do. They don't follow their own laws, and then they work together to try to cover them up. And so it said in there, let me see if it, because this was the main, honey. They let it be known what the dollar amount of my amended complaint is. And I got two motherfucking claims moving forward. So regardless of they talking about they done dismissed all them other people, I'm about to come back and explain to them, no, you're wrong, because all of the stuff you put in there to allow you to dismiss them without me knowing that you was even still ruling on my case. Those are lies, and I have proof of it. I got proof of it. I got proof of it. Let me see. Let me get you my petition for review. My petition for review for, it says, I hereby petition the Judicial Council for review of the August the 19th, 2020 memorandum and order of dismissal of the complainant April Norris Pro Se, who is also identified as an individual with disability. Her August the 29th, this is when I filed the judicial misconduct complaint, August the 29th of 2019. It says, the original complaint was filed in response to events taking place after the state court entered an order on May the 7th of 2018, granting possession and past rent on a unit that had failed the HUD housing quality standard inspection required of all units paid for using federal funds. The complainant was evicted on August the 14th, 2018, after receiving a writ of execution for the May the 7th, 2018 on August the 10th, 2018, after exercising her First Amendment right to freedom of speech while denying her 14th Amendment right to due process and equal protection of the law by being deprived of the opportunity to present affirmative defenses and counterclaims and objection to the second warrant filed against the complainant for claims of unlawful detainer, while she and her minor daughter resided in this federally subsidized multi-family affordable housing development using a housing voucher through the HUD CDBG grant that provides housing and supportive services to individuals and or families with disabled head of households who also have a documented chronic history of homelessness. In this complaint of judicial misconduct, the complainant alleges that the subject judges denied her the right to due process and equal protection of the law by failing to obtain required consent of both parties upon referring the case to the magistrate judge. These people, they sent a form, and I have a copy of it, that asks you if you're okay with them transferring your case to the magistrate judge to help the district judge out. If you don't want your case transferred, you're not supposed to sign this consent form. If you want it transferred and you're okay with the magistrate judge hearing your case, then you sign it. I didn't sign it, and they transferred it to the magistrate judge anyways. We never got case manager or anything, and so the magistrate judge just started doing all kind of crazy stuff, and I'm like, wait a minute, who is you anyway, for one? Okay, now it says the required consent, failing to screen and serve the amended complaint, and undue delay in responding to the motion for counsel filed on August the 17th, 2018. Now, note, when they did this order on October the 26th, they ain't include nothing in there about me asking for them to appoint me counsel as a reasonable accommodation. But see, that's why I'm gonna come back and sue the federal court for violating my right to reasonable accommodations, because you're intentionally leaving out things. It says right here, after the original complaint was issued for service of process on August the 16th, 2018, containing only the remaining claim of housing discrimination under the Fair Housing Act. Let me see. It's allowed. Then I did this complaint because they allowing the Rule 12B motion to dismiss the unscreened and unserved amended complaint to be adopted by the court as the final judgment without addressing failure to obtain consent from both parties as asserted in the motion to assert status of the amended complaint and case management order. I filed so many things with this court asking them, what is going on? Like, can y'all please talk to me? I need to know what y'all are doing. Like, are we going to come in and even possibly have a mediation so we can just settle this? They never gave me the opportunity to speak to a human being other than the front clerk. And I have all of these interactions recorded also. So it says right here, ignoring arguments made in the response to defendant's opposition to the plaintiff's motion for correction of clerical error and motion for set for hearing, conspired with defendant's counsel to interfere with federally protected rights and discrimination against the complainant on the basis of disability, supported by the defendant and the state of Tennessee's history of abusive treatment while having a duty to provide care and denial of constitutional rights of people with disabilities. There's case laws for this too. And I hit them with that. I included all of the People's First and the Arlington Development Center when the United States government sued the state of Tennessee for mistreating those people, and they had to shut that whole facility down. But the state of Tennessee's lawyers stated in their legal documents that the state of Tennessee didn't have the right, the duty, the responsibility to make sure those people ate and stuff because their parents willingly allowed them to come and stay in those facilities. The state of Tennessee said it ain't their responsibility to make sure they taken care of like humans. They told the United States that in legal documents. So the way you feel about people with disabilities is on record. It ain't just me having to come and explain this. So, but they don't mention none of this and none of what I found. Okay. That says in here, and this is my request for review. It says the complainant also made a request for an extension for the time allowed to submit this instant petition for review on September the 30th because of the clerical errors discussed with Lisa, who informed me that she would send an email to Patty Nicely. That's why you always write down names. To have her contact me. However, I have yet to receive a return phone call or email concerning the clerical error. The clerical error being, it says right here, let me see. The chief judge dismissed the complaints on August the 29th of 2019. Wait a minute. The chief judge dismissed the complainant's August 29th of 2019 complaint on August 19th of 2020, almost a whole year later. 10 more days, it would have been a complete year that it took them to send out a dismissal. And then you ain't did no investigation. Okay, and then they mailed the memorandum in order to the complainant on August 24th, 2020. As verified by the attached copy of the envelope received containing the order of dismissal based on the following legal standards. The Rule 11, I ain't gonna read all that off, challenging the subject judge's procedural and substantive rulings being marriage related. Allegations of conspiracy, disability discrimination, and other improper motive being entirely supported by the record. If that was true, and this is what the federal court said, but then they turn right back around in their order that they filed, on what was it, October the 26th, and they're acknowledging that disability, all this stuff was in. I mean, like, come on. Okay, so, but they're saying it was unsupported by the record. Y'all gonna have to make y'all mind up. I said the complainant requested this petition for review be granted for the following reasons. Number one, the chief judge failed to recognize the true merits of this complaint for judicial misconduct. Number two, the chief judge waited nearly a whole year to decide on this complaint without communicating why the initial inquiry or review was extremely delayed and taking longer than the usual amount of time to process. And number three, the chief judge should not have dismissed the complaint based on its conclusion that the allegations were marriage related and entirely unsupported by the record based on its initial inquiry that lasted nearly a full calendar year. According to the Breyer Committee report, the Act states that dismissal is appropriate when limited inquiry demonstrates that the allegations in the complaint lack any factual foundation or are conclusively refuted by objective evidence. At the same time, however, Section 352A states that the chief judge shall not undertake to make findings of fact about any matter that is reasonably in dispute An allegation of fact is ordinarily not refuted simply because the subject judges denies it. Dismissal of a complaint as frivolous under Rule 11C1C will generally occur without any inquiry beyond the face of the complaint. If, however, the situation involves a reasonable dispute over credibility, the matter should proceed. Unless the complainant's allegations are facially incredible or so lacking indica of reliability as to warrant dismissal, a special committee must be appointed because there is a material factual question that is reasonably in dispute. The chief judge received this complaint from the circuit executive on September the 4th, 2019, but did not contact the complainant for further inquiry or investigation before issuing a determination of dismissal on August the 19th of 2020, nearly a full calendar year after the complaint was filed by the complainant. The order of dismissal was not mailed out to the complainant until August the 24th, 2020, 5 days after the order was entered, and the complainant did not receive it until August the 27th, as she had no idea to be checking her mail on a daily basis without hearing anything from the court in nearly a year. This grossly delayed order of dismissal shows evidence of clear misinterpretation of the merits of the complaint. The actual record of the underlying matter shows evidence that no consent was obtained by the magistrate judge and no scheduling order was entered, even after the complainant objected to the magistrate judge's jurisdiction as part of the motion to a certain status of the amended complaint and case management scheduling order pursuant to 28 U.S.C. 636C1. No disability-related reasonable accommodation alternatives were offered after denying the complainant's motion for court-appointed counsel as a disability-related reasonable accommodation that was filed along with the amended complaint on August 17, 2018, after the court dismissed all claims against the defendants for procedural and technical deficiencies except the claim of housing discrimination under the Fair Housing Act. Okay, there's some more I wrote in there, but I requested a temporary injunction. They denied that. No answer was ever required to be filed by the remaining defendant in the response to the original complaint that was screened and served on September the 4th of 2018 on the only remaining defendant included in the August the 10th, 2018 complaint that was finally served after unnecessary delay caused by the district court clerk's office disputing against the manner of service used by the East Tennessee Marshal's Office, who on August the 16th of 2018 obtained jurisdiction to perfect service of process using methods approved by the U.S. Marshal's Office, who later confirmed that the manner used by the East Tennessee Marshal's Office was sufficient. Default judgment was appropriate pursuant to Federal Rule Civil Procedure 55A. Anyway, I went on, okay, I got a couple more, I can read it. No screening or service of process of the August 17, 2018 informal properous amended complaint was perfected on any defendants included even after filing the motion to a certain status of the amended complaint before the amended complaint was dismissed based on the unverified and unsupported legal arguments and blanket denials asserted in the defendant's Rule 12B motion to dismiss. It says the complainant suffered and continues to suffer emotional and financial damages caused by the subject judge's misconduct, conspiracy, fraudulent misrepresentation of material facts, and disability discrimination, as evidenced by the complainant's continued homelessness and family separation caused by wrongful termination and eviction from a federally funded homelessness prevention program created to end and prevent homelessness for individuals and families who have a documented disability and chronic history of homelessness. If you all think back to what I was reading y'all about, what the court issued, their last order, they didn't do nothing but recite a whole bunch of the stuff that I put in here, because before they didn't have nothing and they admitted it. They don't know nothing about it. This is going to be one, what you call that, when this is the first time a case done came up. We're going to take this shit to the Supreme Court. Watch. Because I got proof that they all got their hands into this. and been looking the other way. Okay. It says right here, this collective action by the subject judges, the court staff, the state court judges and staff, and other legal entities involved shows a clear example of overlooked judicial misconduct, attorney misconduct, and conspiracy to retaliate by failing to act to protect the complainant's rights to exercise the First and 14th Amendment rights protected by the U.S. Constitution. The final order from the state court proceeding referenced in the chief judge's memorandum and order is not merits-based, which is obvious from the four corners of the state court final order, and it also does not contain any case law or relevant legal citation to support its decision, and should have been addressed as deficient upon the appeal that was also referenced in the chief judge's memorandum and order. As stated on page 12 of the Guide to Judiciary Policy, Volume 2E, Chapter 3, an allegation that a judge conspired with a prosecutor to make a particular ruling is not merits related. Even though it relates to a ruling in a colloquial sense, such allegation attacks the propriety of conspiring with the prosecutor and goes beyond a challenge to the correctness, the merits of the ruling itself. An allegation that a judge ruled against the complainant because the complainant is a member of a particular racial or ethnic group, or because the judge dislikes the complainant personally, is also not merits related. Such an allegation attacks the propriety of arriving at rulings with an illicit or improper motive. Similarly, an allegation that a judge used an inappropriate term to refer to a class of people is not merits related. Even if the judge used it on the bench or in an opinion, the correctness of the judge's ruling is not at stake. An allegation of a habitual pattern of delay in a significant number of unrelated cases, or an allegation of deliberate delay in a single case arising out of an improper motive, is not merits related. For the above-mentioned reasons, the complainant requests that this petition for review of the Chief Judge's memorandum and order of dismissal of complaint number 06-19-90056-57, because it was 2, be granted to allow the true merits of the complainant's complaint to be reviewed fairly pursuant to the established laws relevant for federal complaints of judicial misconduct. Respectfully submitted by April Burns-Norris, pro se litigant. Bloop, bloop, bloop. And that's why they turned around a whole year later and came back and said, oh, well, we can give her these 2 claims. But bitch, it's still 10 million. And I'm going to need interest. And then I'm going to come back and smack you around and correct all your little lies that you told. Justice by any motherfucking legal means necessary. That part, period. Community Bridges Incorporated. Housing Me Too. Connect the dots. We coming. Power to the people. NFAC for life, motherfuckers. And we out this bitch.